Today's lecture will focus on criminal law, definitions of crimes, but also some of the sources of law, where we get that from. And we touched on that some in the first lecture, but we're going to look more specifically at that today, just breaking down types of offending into large groups. So just take for a second and think about what types of crimes you might have, you might be unsure about, like what their definitions are, how they're defined, why they're defined in a particular way. There've been a lot of questions recently about why certain offenses are charged as murder versus manslaughter, degrees of murder, and we'll look at some of those delineations here in the slides. I'll also put a link to the Georgia laws, so you can look at those and see what that looks like, what the actual definitions of the different laws are in Georgia. So we talked again about this at the beginning, consensus model versus a conflict model. Consensus model basically means that everyone, or at least most people, are in agreement about what types of things should be criminalized. Conflict model is where those that are in power have the ability to make laws, use that power to make laws that are counter to the will of the people. A really good example of that is happening right now in Hong Kong, where the government there had an agreement with the mainland Chinese government when the control of Hong Kong was given back to the Chinese government following the removal of the British power there. They were supposed to have, I believe it was 50 years before they could have a major overhaul of the laws to make it more in line, more strict, as those are in mainland China. They have recently, in the past year, and faced a lot of protests for this, tried to invoke those laws early. And the first time there was a lot of protest and the government kind of relented, and now they're trying to do that again. So we're seeing that play out in sort of in real time, in conjunction with the other things that are happening on a global scale. Types of criminal law that we have. So again, we're talking mostly about criminal law today and their definitions, criminal offenses as opposed to civil law. We'll talk a little bit about that later on. The two types of criminal law that you have are substantive law, and I'll put a link. I'll put a link on this slide before I post it, so that you can see what the Georgia substantive law looks like. And then procedural law. So substantive law is all of the crimes being defined. What is murder? What is robbery? What are the different degrees of those things? What actions constitute those behaviors? And also, what are the set punishments for those behaviors? Procedural law dictates how the criminal justice system operates, how the courts proceed, how those rulings from the court are then carried out by the correctional system, also the rules of procedure for police and collecting evidence, obtaining warrants, and things like that. The three sources of criminal law that we have, and the first one is represents the vast majority, statutory law, laws based on statutes, which again I'll put the link on the slide for you all to explore at your leisure when you're going through this PowerPoint. Just every the code, and in Georgia we call it the Official Code of Georgia Anointed. Different states have different names for it. You also have the federal laws, just the laws that are codified. When you would think of law books, anything like that. That's the vast majority of law today. Also, you have case law, which is when the court makes a ruling or decides in a case about what's going to happen, either the application of statutory law that's already in place, or potentially the creation of new law, depending on the circumstances of the case. Typically, when you have a court proceeding, they're going to rule based on the way that rulings have happened in the past. But sometimes circumstances are such that the judges make a different ruling, creating new case law. The other thing is that it could be interpreting a law. For example, today, which is the 15th of June, the Supreme Court just applied a 1964 civil rights law to protect LGBT community members in the workplace, so that you can't be fired for um, sexual orientation or gender identity. There are less than half of the states right now have any kind of stringent protection for individuals, for community members in those groups, in the workplace. But the Supreme Court has ruled that the 1964 law, which has been in the past interpreted to be based on biological sex, and also race, cultural things as well, now applies to these wider criteria. So they created new case law. So that's going to, basically be the law, and then will be further codified in statutory law in the individual states, and probably also at the federal level. The last type is not really used anymore. Common law. Some states still have laws on their books based on common laws, but it were basically just standards and practices that were accepted across the majority of the community or government, whatever, what have you, that was living by them. Um, it was more common 200-300 years ago to have more types of common laws. I've heard the term common law marriage, that if two people live together for 7 or 8 years, then they're considered married. A lot of those laws have been removed from the statutory laws, and they don't have any applicability in modern American government. But it is an old source of law that was used more frequently in the past. So like I said, two types of law. We talked mostly before about the criminal law, sources of that. Civil law is basically just um, disagreements between two parties. So criminal law is always going to be the state, uh, the city, the county, the federal government versus the defendant. The reason they do that is to remove the familiarity that the victim might have with the defendant, and it also goes to the principle of um, our legal system, that you can't consent to be the victim of a crime. So if someone, for instance, allowed someone else to murder them, that's why we have the government versus that person, because you can't have that happen. Civil law is basically matters or disagreements between two people. It usually involves what's called a tort, which is a harm that's been done to one party, usually seeking some sort of satisfaction. Most commonly, that is money, either to receive money or to receive property from the individual. A large civil case that was just decided involved the Tiger King show. The one individual, Joe Exotic, lost a settlement to the other zoo owner, Carol, in the show, of over $1 million. And because he didn't have the money to pay for it, his property at the time, which was the zoo, was just recently turned over to Carol, um, because at the time that the harm happened, he had those assets, and he tried various methods to hide them. But the eventual outcome is that the one individual that was harmed, can't really go into the specifics of the case. That's 6 hours of Netflix. Can't really condense into 15 minutes. I would watch it. It's a roller coaster ride through uh, the depths of American society. But a civil case is basically harm done by one party to another party, and then seeking satisfaction for that. That could be two people. It could be a person and a state. It could be two states. It could be corporations. There's a lot of legal entities that can get involved to raise civil issues. Okay. Some defenses for law breaking, and again, it's important to note that most of these are not um, going to prevent someone from being convicted. Some of them will. A lot of them are basically just mitigating circumstances. So reducing the charges, or offering just again some explanation as to why it took place. The first is mistake of fact. Again, it's most of the times ignorance of the law is no excuse, but if there's a specific law that or if laws and norms conflict with oh, no, sorry, that's matter of law. Matter of fact is the person is uh, unclear or misinformed for some reason about the circumstances, and so they act in a way that if they had potentially acted in that way towards another individual, it might be different. So if someone um, uh, a sort of morbid example of that would be someone accidentally killing a family member thinking that they were a burglar. They didn't, they've committed this crime. Typically, it would be a manslaughter in that case, but they didn't intend to do that. They thought they were doing something else. So a lot of times, those cases, um, it's, I mean, depending on the circumstances, the sort of harm done to the overall situation is allowed to be the outcome there. Mistaken law, that's what I was alluding to at the beginning, is where there are some places have uncommon laws, things that aren't, things about curfews, even like open alcohol container laws vary from place to place. So again, it's not something that would have that remove the penalty, but if you argue that in court, a judge might reduce the charges or reduce a fine that might be paid, depending on if the mistake is reasonable or not. The next is duress, where someone makes someone else commit a crime. Back to the Netflix again, there's a documentary on there about a pizza delivery driver who was forcibly strapped with a bomb and told to rob a bank. A situation like that would be a duress. You could argue a duress defense. Now, duress defense does not work for homicides. So if someone, for criminal homicide, so if someone were to have a gun to someone's head and say, I'm going to kill you if you don't kill this other person, the law says you have to let yourself die. You can't argue a duress defense in those circumstances. Again, we're talking in very specific terms that almost never actually happen, but just sort of drawing the boundaries of the lines, drawing the boundaries of the laws so that we have them should we need them. Next is entrapment, which is not really something that's argued very much anymore. This was in the next PowerPoint, you're going to look at a lot of police Supreme Court-based cases, and the entrapment defense became less popular as the police were better informed by the courts about what they could and couldn't do in particular situations. So modern policing, entrapment's not really much of a defense because the police know what rules to follow and what they can and can't engage in terms of undercover criminal activities. The next, consent of the victim. Again, it's not something that you can that's going to exonerate someone from a particular offense, but usually, if someone sees something that looks like a crime, but it's actually not a crime, that might be consent of the victim. In that case, the crime really hasn't taken place. So. A common example would be if a neighbor overheard commotion, loud noises, potential signs of violence coming from an apartment, and called the police, which is what you should do in that situation. If you think that there's violence taking place, especially to try to prevent things like domestic violence, if you know that that's an issue, you certainly would want to call the police in that situation. So say that happens. Maybe the neighbor had done that in the past for someone when that had actually found out to be the case, that there was domestic violence taking place. They called the police and it worked out. So they're hearing this happen. in a different apartment, and they call the police. The police get there, and they discover that the signs and sounds of violence that they were hearing were actually consensual sex acts. So that's something where the crime's not really taking place, um, and the line between consenting sexual acts for adults and potential violence can be very thin in some circumstances. So it's important to note to have these laws in place, and where the definitions lie, and have that very clearly defined, so that when we get into the situations where that was not a bird, that was my phone. When we get into these situations where um, you have to make decisions based on a lot of different specific circumstances, um, it can be easier to have a consistent outcome. Let me just turn my ringer off. Okay. The next is self-defense, and it's important to note that if you are not in a state that has one of the stand your ground laws, which is very few, I think there's only 4 or 5 states that have that: Florida, Colorado, Oklahoma, I think New Mexico. This is not a legal class. I am not a lawyer. Do not take legal advice from me. So the majority of states don't have stand your ground laws. So the self-defense standard, self-defense, defense of others standard, is that you can only respond with the level of force that you are presented with. And in fact, in most circumstances, you have a duty to retreat from the situation if you can. If you can get away from a situation, somebody presenting violent threat to you or others around you, if you can remove yourself from the situation and maintain the safety of yourself, the safety of others, then you're supposed to do that. The exception to that is within your own home. There's no duty to retreat in your own home. But so the main thing is you can only respond with equitable levels of force. So if you see someone punch someone, you can't walk up behind them and shoot them. You can't respond to a one punch with deadly force unless the person punching the person being punched is 4'9" and the person punching them is 7.5 feet tall. Again, there has to be equitable levels of force with what the threat is being presented. Next is necessity defense, which typically is defense for fairly small crimes, things like speeding on the way to the hospital, things of that nature. There's not going to be any sort of necessity defense for robbing a bank. So again, smaller offenses that are being broken to prevent a larger harm from taking place. The next is immaturity, and this is important, and we'll look at this more in the juvenile justice section later on in the semester. Different states have different laws about this. For the most part, anyone under the age of 7 to 5, depending on what state you're in, can't be charged with a crime at all. Doesn't matter what the crime was, they can't be charged. From that top end age to about 12 to 15, again, depending on what state you're in, it's usually up to the discretion of the prosecutor whether or not they want to bring charges. Depending on what the charge is, that could result in individuals being tried as an adult if it's a very serious offense. It could also dictate what type of punishment they receive. So that is an issue. And again, it's very situationally specific, depending on what state you're in, what the laws are there, the exact age of the individual when the crime took place, and also what the crime was and what are the circumstances there. The next is intoxication. Very important to note that voluntary intoxication is not a defense for a crime. If you get too turned up, that is your own fault. Okay, so voluntary intoxication is not a defense for a crime in any circumstance. Involuntary intoxication is a defense for a crime, and what that is if you are drugged, or if you are, basically just drugged without consent or without knowledge. There was a case in Las Vegas where 2 people were partying. One friend put a hit of LSD in the other friend's beer. He didn't handle the psychedelic drugs very well, freaked out, and killed the friend that had spiked his beer. He wouldn't have done that if he hadn't been drugged, So he had an involuntary intoxication defense. The next type of defense we're going to talk about is the insanity defense. We're going to go on to the next slide for that. So the understanding of the insanity defense has changed a lot over the past 100 or so years as our understanding of mental health has changed. Um, and I only really want to focus on what it means today. So what it means today is at the time that the crime was committed, did the individual understand that what they were doing was wrong? That doesn't take into account past or current psychological diagnosis. I mean, it does, but those things aren't automatic indicators of the person not being able to appreciate right and wrong at the moment. So we have understood that mental health conditions sort of fluctuate with how prevalent they are in impacting the perception of a particular individual. So they um, if they have peaks and valleys and how affected they are, it's important to note when the crime took place to determine if they will be held accountable or not. So there's a couple things that can happen with a insanity defense. The first is that the person is found not to be able to stand trial, then they're going to be remanded to a mental health facility until such time that they are able to stand trial, to participate a little bit in the process. If they go through the trial process and it's determined that the person was not able to appreciate that their actions were wrong, they won't be released. You don't get released on an insanity defense. Again, you're remanded to a mental health care facility until they determine that you're not a threat. You're not going to be a threat in the same way that you were a threat that committed the crimes. If during the trial process it's determined that they were able to distinguish between right and wrong, then they will most likely be found guilty if they're proven guilty at trial, and then they will face normal correctional sanctions. Okay. Again, two broad classifications of crime, and we talked about this in the previous lecture, the first lecture. Mal and say are things that are inherently bad, and we talked about why some of those things were defined as bad and sort of reducing the social capital that you have in a community. But then you also have mal prohibita, which are the things that we define as crime, either through a consensus or a conflict model. They weren't. They're not inherently bad. It's just that either the community has agreed upon it or the people in power have agreed upon it that these things are going to be outlawed. Excuse me. The types of crimes that we have in terms of criminal violations: felony, the most serious crimes, which are punishable by over a year in prison and over $1,000 fine. A misdemeanor is defined as a crime punishable by up to a year in jail and up to $1,000 fine. There's a lot of court costs and other fees that can go along with that make the fine much higher, but the base punishment caps out at $1,000 for the fine. And then you have violations, which are criminal acts, but they're not very serious. They often have a very small jail punishment or no jail punishment, just a fine. Doesn't go on any kind of a criminal record. It's not going to show up on a background check for a basic level background check. If you're trying to work at the CIA, then they're gonna check on stuff like that. But just a less serious offense. The types of crimes that we have, and again, you can see a lot of these listed in the Official Code of Georgia Anointed. So I'll be sure to drop that link in the earlier slide. You can go back to that and check some of these out. Violent crimes, property crimes, organized robbery, gang theft, white collar crime, which is basically crime that occurs at the workplace. It doesn't have to be corporate level. It could be someone working at McDonald's or Walmart, all the way up to really any job. Any job can involve crime. Organized crime, the Italian mafia, the Russian mafia, Japanese yakuza. There's a fairly heavy Jewish mafia presence in Atlanta. A lot of lot of groups, racial groups, cultural groups have organized crimes that form in their in subsets of their culture. Um, yeah, professional theft again, not doesn't happen that frequently, but it does happen. People do try to steal stuff from museums and steal millions of dollars in diamonds. So that does happen. Hate crimes, crimes in the political system. Oftentimes those are white collar crimes, and then some that we call victimless crimes, which are a lot of the drug offenses. Some prostitution related offenses, although the understanding of that type of criminality has evolved considerably over the past 20 to 30 years. So the first type we're going to look at is criminal homicides. Homicide just means that one human being killed another human being. It doesn't take into account legality, motive, or anything like that. So criminal homicides, we break into two categories: murder and manslaughter. Murder has to have premeditation. Okay, so that's the major delineation between murder and manslaughter is premeditation. Malice aforethought is what it's called. Not necessarily planning, but it's the best example for delineating manslaughter and murder. And really, there's two types of murder. In most places, some places have three. For the most part, it's two. And that's murder one, murder two. Georgia, we call it felony murder, and then murder. Felony murder has planning or occurs during the commission of another felony. But the best way to delineate manslaughter and then the two types of murder is if a person walked into their house and found their significant other engaged in romantic activities with someone else, and they opened so they walk into the room, they open a bedroom drawer, pull out a gun, and kill both people. That would be manslaughter. Okay, there's no planning, there's no thinking about what happened. It's sort of what they call a saw red moment. Now, that same situation happens, the person leaves the room, goes to the store, promptly buys a gun, and then comes back and kills them. That would be second degree murder. Okay, so you didn't really plan it. You didn't like plan out a hitman or hire a hitman, but you had some time to think about it, and you still did it anyway. The top count, murder one, felony murder, would be basically seeing that, leaving, and then planning it out for a week, or hiring a hitman, something like that. It's very important to know the motives, what type of cooling off period, what kind of time frame the person's working with to determine what type of offense it's going to be. Like I said, there's two different types of murder, and the top one, felony murder, doesn't require planning or premeditation if it occurs during the commission of another crime. And an example of this happened in DeKalb County last year, where two individuals attempted to rob a Subway. So you have one individual that has a firearm, the other accomplice doesn't have a firearm. They go in there to rob a Subway. The owner or the worker there, in the course of trying to prevent the robbery, kills the suspect with the gun. The other suspect was charged with murder because a death occurred during the commission of a felony. And because when you engage in violent felonies, death is a common, if not likely, outcome. Because it was a foreseeable outcome, you are responsible for that happening. So he didn't have the gun, but he participated in the robbery and a death occurred. So he was charged with murder in that case. And so you don't have to commit the murder to be charged with it. Some other definitions of crimes: assault and battery, often misused. Assaults are threats. Batteries are hits. So you say, "I'm going to kick your ass." That's an assault. If you engage in the kicking of the ass, then that would be a battery. Some states have different levels, aggravated. Some states even have mayhem statutes still on the books, which is basically an aggravated battery where someone loses an arm or an eye or something like that. There's a permanent maiming happening. Most places just have aggravated battery statutes. So assault is a threat, battery is the hitting. The other types of crimes that are often um, uh, the the verbiage for them is misused is robbery and burglary. And the easiest way to tell these apart, people are robbed, places are burgled. So if you are stealing from an unoccupied structure, that's a burglary. If anybody is there, it's a home invasion, which is a type of robbery. Okay, so people are robbed, places are burgled. Arson straddles both the property crime and violent crime spectrum. There are three types of arson, three levels. Third degree arson is the burning of an unoccupied structure for no real purpose, okay, just destroying property. Second degree arson is the burning of an unoccupied structure for the purpose of some financial crime, fraud, or something like that, trying to get insurance money. First degree arson, which is a violent crime, is the burning of an occupied structure. It doesn't matter what the purpose is. So whether it's just to burn it or whether it's for insurance fraud, burning an occupied structure is first degree arson and a violent crime. Some other types of property crimes, theft. Um, Theft is basically just taking, could be a lot of different things. It could be identity theft, digital presence, any type of taking of property or goods or anything like that. Larceny specifically is thieving things, so stealing stuff, whether that's something from someone's house or stealing from cars. It's basically a specific type of theft. Shoplifting is a specific type of larceny, so stealing from a business, a retail store, something like that. Embezzlement is stealing funds that you have legitimate access to. So stealing from your company, stealing from petty cash, or stealing from a city if you work for that city, things like that. Fraud is the misrepresentation of some aspect, typically dealing with a financial situation. So requiring payment for services that haven't been rendered. There's a lot of different things that could be fraud, basically misrepresenting something. Forgery is creating a physical falsity, creating a fake painting, creating fake shoes, bootleg sneakers or bootleg bags, Louis Vuitton bags, Coach bags, creating that false product. Oftentimes, forgery and fraud go sort of hand in hand, depending on how some of the financial transactions are carried out. Plagiarism is also another type of property crime, and it's stealing intellectual properties, whether that's writing or music or film or art itself or copying photos, things like that, taking someone else's work and putting it off as your own or using it improperly as well. This slide has a breakdown of sex crimes. Um, the most serious of which is forcible rape, oftentimes having a violent component. Doesn't have to have a violent component. There's coercion. There's other types of, or drugging, things like that. There's other types of ways that control is maintained in those during those crimes. Um, the next is statutory rape, which basically means that the sexual contact occurring between the individuals is illegal based on the laws of that area. In the past, it had been used against people of other races. These types of laws and other types of laws, some of the fornication laws were used against LGBT community members. The most common implication of statutory rape is where the age of the individuals is legally defined as criminal. Someone is over 18 or under 18. Again, it's very specific as to what state you're in, what types of contact occurred, as to whether or not it's going to potentially be a crime or not. Fornication, again, was laws that were kept on the books a long time after they were really enforced, basically to target Mostly they were aimed at targeting gay men and charging them with a crime. But it was originally on the books for anyone that was unmarried that engaged in sexual activities in a lot of places. It was illegal. But a lot of those have gone off the books since then. They've also removed a lot of laws against sodomy. Any type of oral or anal sex was illegal in Georgia before about 2003, 2004. So a lot of those laws were just kept on the books, again, to particularly target um, minority cultural, uh, well, basically targeting. Some of the older laws were trying, especially in the South, were trying to reduce interracial couples, but a lot of them were kept on the books to target LGBT community members by in sort of a conflict model by policing a particular behavior because it was illegal for them to be married. Any sex acts they were engaging in would be considered illegal fornication. Um, so again, it's the conflict model in practice in the United States. Pornography can be a crime in three different ways. First, if the people in the uh, depictions are under the age of 18, it's illegal. If someone is made to watch it, it is illegal. You can't force someone to watch pornography. The third, as defined by the Supreme Court, is if the content violates the standards of society. That's a pretty loose one, and the internet shows that there's not much that violates societal standards based on the content that is available online readily. Um, the main thing that's really only um, not permitted in terms of pornographic behavior. So some laws have developed prohibiting, probably, rightly so, sex with animals. Um, Also, again, you can't consent to be the victim of a violent crime, so sometimes there's a fine line between that and what kind of content is shown. But the third one is a pretty loose requirement that going against societal standards. Um, Prostitution is in Nevada, in counties that have less than 100,000 permanent residents, the county can vote to allow prostitution. That's the only place in the United States prostitution is legal, is in various counties in Nevada, not including where Las Vegas is, because there's too many people that live there. Um, a lot of policing and the criminal justice attention in the past has been focused on the prostitutes. Our understanding of this crime has evolved over the past 20 or 30 years to focus more on the Johns, the people that seek the services, and also the pimps, and also the traffickers, because it's basically um, it's one of the largest slave markets that still exists in the world, is sex trafficking. So we focused more police efforts and law enforcement efforts, criminal justice efforts in courts, enforcing international laws and things like that, to try and uh, help the people that are being the real victims in these cases, while preventing and punishing the people that are promoting the behavior. Um, Indecent exposure is what it sounds like, showing it in public. Voyeurism is looking at it when you're not supposed to be looking at it in public, or looking into people's windows, things like that. Seduction is another one of those older laws, and it kind of ties in with like fraud almost. It's the old wording of it is getting a lady of chaste to engage in sexual activities based on false pretenses. So the old method of that happening was saying that you would marry someone so that they would have sex with you and then not marrying them. And then in the olden days, some culture still today, um, individuals that have engaged in sexual activities already are not seen as um, it, are not seen as attractive mates in some cultures and subsets of cultures. Um, okay. Also, we have, it's on the slide at the end, drug law violations, and that's basically based on the continued increased prohibitive nature that we have in this country, focusing on the war on drugs, which is not effective. We'll talk more about that later in the semester. But drug laws, basically just prohibiting various types of drug usage, whether it be possession, sale, trafficking, creation of the drugs, various types of offenses for those activities. Some other types of crimes: disorderly conduct, minor, not necessarily violent, drunken, disorderly, things like that. Harassment and stalking, we have a pretty rough, not effective history at policing. Oftentimes, it's hard to articulate to satisfy the law enforcement requirements for seeing that these things are happening. So a lot of times, victims aren't believed until something truly bad has happened. So that's another type of criminality that the police are trying to get better at, but they're not progressing as fast as they really need to. Loitering, DUI, gambling, those are all pretty self-explanatory. Gambling's interesting because a couple years ago, 2 years ago, about this point, 2020, the federal government, Supreme Court, ruled that the federal prohibition on sports gambling was illegal, unconstitutional. So that's been removed. So since then, various states have increased their capacity for accepting sports bets. So that's something that's sort of a developing marketplace, where before a lot of that gambling had been done illegally. So because you couldn't gamble, you couldn't place a bet in New York or New Jersey. That's where you had a lot of bookies and things like that would take the bets, and hopefully if you won, they paid you, because if you lost, you were definitely going to have to pay them exorbitant interest and things like that. So they've tried to legitimize that and remove some of the criminal elements from that segment. Okay, so these are the criminal definitions that we're going to go over, that we've gone over. Like I said, go through the link on the Official Code of Georgia Anointed and sort of check out some of the types of crimes you maybe had questions for. You can actually see the definitions of those things, and look at the specifics of Georgia and how it might be different in other states.